The first article says upholding the autonomy of the Election Commission. Let us try and understand what is this article all about. We have the Election Commission of India. The Election Commission of India draws its authority from the Constitution of the country. We have Article 324 of the Indian Constitution. It speaks about superintendence, direction, control of elections is vested in the Election Commission of India. To run the operations of the Election Commission, what we have is the election commissioners. We have the appointment of the Chief Election Commissioner. We also have the election commissioners as well. The Chief Election Commissioners and election commissioners are appointed by the President. So it is the President who makes an appointment for a tenure of about 6 years, or this person will be appointed up to the age of 65, whichever is earlier. And when it comes to the advantages and independence given to the election commissioner, they enjoy the same status, salary, perks as that of the judges of the Supreme Court of India. So this article here is primarily speaking about the appointment procedure of the election commissioners, and recently the Constitution Bench of the Supreme Court of India heard a crucial case about the method by which the Election Commission of India is constituted and the election commissioners appointed. So this article is primarily speaking about that there were a number of cases that were filed in the Supreme Court of India. The Supreme Court of India is listening to the cases about the appointment procedure of the election commissioners, and in all likelihood it may give us a judgment in the month of January. So this article here is primarily speaking about whether this appointment procedure that is currently being made by the President means equivalent to the Council of Ministers, is it right or wrong, is what is this article all about. Let us try and understand in detail a larger picture about this article. When it comes to the classical idea of democracy, we have three organs of the state. Which are the three organs? We have legislature, we have executive, we also have the judiciary. The legislature make the law, the executive implement the law, and judiciary interpret the law. When it comes to the implementation, what we have is number of bodies. For example, we have the National Human Rights Commission, we also have the UPSC as well, we also have the Election Commission of India, which is also an executive body. When it comes to such body, for example the Election Commission of India, when you consider the classical idea of democracy, they are usually under the control of the executive. So the classical idea of democracy, or the paradigm of democracy according to the classical theory, goes on to say that if there is an administrative body, if there is an implementing body, this implementing and the administrative body is usually appointed by the executive, and all the operations of this body comes under the political control of the political executive. That is what is the classical model of democracy. However, the author goes on to say we have to change with changing times. In the contemporary scenario, what these executive bodies, that is the implementational and the administrative bodies, should not directly report to the executive. Instead, what they should have is an arm's length operations from the executive, and they should be given more independence. And as a result, these bodies are what are called as the fourth branch institutions or the integrity institutions. So the question is, what is this fourth branch institutions? In the Indian context, institutions of the fourth branch include Election Commission, Lokpal, Central Bureau of Investigation, Reserve Bank of India, National Statistics Commission, National Human Rights Commission, Information Commission, Commissions for various marginalized groups, Central Vigilance Commission, Comptroller and Auditor General, Attorney General, Public Service Commission, University Grants Commission, Finance Commission, Niti Aayog, Media Regulators, and many others. So what are these fourth branch institutions? Let me simplify this process for you. We have the Election Commission of India. The Election Commission of India is appointed by the government, which means the President goes about appointing. Indirectly, it is the Council of Ministers, which means it is the government. What is the role of the Election Commission of India? The Election Commission of India ensures that there are periodic elections that happens in the country. So the Election Commission of India will have to be independent. It should not support one political party. But who is making the appointment? When it comes to the appointment, it is made by the government. For all cases until now, the Election Commission of India has always been neutral in most of the scenarios. There have been election commissioners as well, like Session, who were able to impose the authority of the Election Commission of India. But let's say in a hypothetical situation, because it is the government making the appointments, what if the election commissioners stand in favor of the government? So it is in this particular backdrop, despite being an administrative and the implementing agencies, these bodies should be completely away from the executive. So this article says if an appointment is being made To such officers, what we require is the support of the opposition political party. We also will require the speaker. It will also require some guidelines which have to be given so that this particular election commission acts in an independent manner. As of now, since the appointment is being made by the executive, as of now, there are no issues in the past. They have been able to maintain the neutrality, non-partisanship, impartiality. But what if they have a reciprocity quid pro quo that it is because this political party has appointed them? What if they go on to become and support this political party? In order to avoid it, in the contemporary times, in the modern times, these executive agencies should have an arm's length distance and they have to be completely independent. So their appointment procedure should also be neutral and should not be with the executive, says the author. This is where the author also takes another example as well. We have the information commissions. The information commission, let's say we have the RTI, the right to information. The right to information is where, let's say for example, you want to seek some information, I want to seek some information. What do? We ask this information from one of the government departments. This information that is given by the public information officer might be against the government. In this case, those governments which are in power, they wouldn't want to reveal such information because it could become a threat to their operations. So in these cases, if the information commissioner is appointed by the government, do you think that they would be able to do justice? No, they may appoint such person who will listen to the government. So in this particular case, this entire RTI, the right to information, where information is sought out, will not be an effective exercise. Instead, it will be a toothless tiger, says this article. Similarly, we also have the Central Bureau of Investigation as well. In the past, we have the Supreme Court of India, which is called the CBI, the cage parrot, because it happens to listen to the government. So all this means the fourth branch institutions, the integrity institutions, should not only be deriving its powers or appointment made by the executive. Instead, it should have a larger canvas where opposition is taken into picture. You also have the speaker or any other person with integrity, and you also require some judicial officers like the Supreme Court judges, is what is this article all about. In order to take an inspiration, we have number of examples in number of countries. For example, the South African and Kenyan constitutions have dedicated constitutional provisions for fourth branch institutions such as human rights commissions, election commissions, and so on, calling these integrity institutions and requiring them to be independent. The appointment process for such bodies normally involves multiple stakeholders from different wings of the state. This is what the author is trying to say. He says that whenever you're making an appointment to the election commission, that is, the election commissioners are appointed. Who is making it right now? It is the executive. He is appointed by the president. President indirectly means the council of ministers. This should not be the way. But instead, what we require is all the organs represented. Let's say we come up with a committee, and this particular committee also has the leader of opposition. Then there is also the prime minister or anyone from the government, and we also have one from the judiciary. Let's say, for example, the CJI or any of the judges nominated by the CJI. So one representing from the Supreme Court or the judiciary. If they are present in that case, then there might not be quid pro quo, is another recommendation. So this article goes on to say that as the South African Constitutional Court correctly noted in one of the landmark judgments, true and functional independence is effectively impossible if the power to appoint rests entirely with a single individual, office or entity. This then is the foundation of the ongoing dispute before the Supreme Court, says the author. As of now, it is being made by the government, that is, president appoints, which means the council of ministers. It is with one single office. This should not be the way. Instead, what we require is a larger picture that has to be considered, says the author. In fact, in the landmark Vineet Narang case, the Supreme Court likewise held that for the rule of law to prevail, the appointment of the CBI director would have to be ratified by a three-member body that included Prime Minister, Leader of Opposition, and the Chief Justice of India. So similar such attempts will also have to be taken with respect to the Election Commission of India, says the author. So the appointment processes involve the government, the opposition, independent experts, and judicial experts in a manner that no one center of power has dominance or a veto, is one of the recommendation given by the author. So this particular case is right now in the Supreme Court of India. The Supreme Court of India in all likelihood will deliver its judgment in the month of January. So the Supreme Court should not overstep its jurisdiction. Instead, must give the basic fundamental guidelines. These guidelines will have to be followed by the legislature and ultimately, as we just discussed, come up with a committee so that everyone is representative of it and there is due process, rule of law that is followed when it comes to the appointment procedure of the election commissioners for the country. So this article goes on to conclude, for all fourth branch institutions, which are called as integrity institutions, they might be administrative and implementing agencies, despite the classical form of democracy saying that it is the role of the executive to appoint. But in the contemporary times, you require a larger mechanism where all three organs of the state will have to be present and they make the appointment, so that there is arm's distance for these implementing agencies away from the executive, is what is this article all about.